Hi, and welcome back to Focal Point AFR Talk. Brian Fisher is my name. You are listening to Focal Point, the home of muscular Christianity on Conservative Talk Radio. The network is AFR Talk, American Family Radio Talk Network. We've been talking today about some of the fallout, some of the aftermath, some of the debris that's being scattered by the Supreme Court decision overturning DOMA and sending Prop 8 back to essentially to the Ninth Circuit. We had kind of some surprising and I believe actually unconstitutional movements on the part of the Ninth Circuit in the wake of this. And here to help us sort through all of that is Dale Schowengerdt. Dale is an attorney with the Alliance Defending Freedom, and the ADF defended Proposition 8 in court in California all the way through the process. Dale, we've had you on before. Welcome back to Focal Point with Brian Fisher.
Thank you, Brian. It's good to be here.
Well, Dale, let's I want to go back and revisit, and maybe you can provide some clarification for me. I've got a couple of questions about some of the legalities and the protocol over how this Proposition 8 case was handled. Now, my understanding, correct me if I'm wrong, but my understanding is when the Supreme Court vacated the ruling from the Ninth Circuit, they sent it all the way back to the trial court, Von Walker's trial court, in which case the only people that would have been allowed to perform or enter into a same-sex marriage would have been the two couples who were plaintiffs in his court, and in his ruling would have had no impact beyond those two couples, or if it did, it wouldn't extend beyond the two counties or so that were part of his trial court, so or jurisdiction. So am I right about that, or am I misunderstanding something?
No, you're understanding it correctly. And in fact, when the case was at the Ninth Circuit Court of Appeals, two of the judges, two of the liberal judges on that court, kind of chided the plaintiff's lawyers for not filing this as a class action, not certifying a defendant class, because, as a technical matter, it only applies to those four individuals, those two couples that filed the lawsuit, especially since all we have is a one district court decision from a lone federal judge in San Francisco.
Now, the court ruled, and help me on this one too, the court ruled that the plaintiff or the defendants, that would be ADF and others that you were representing, that the defendants of Prop 8 had no standing. They weren't even eligible to be in the courtroom. They had no right to enter a court and plea on behalf of this legislation. And therefore, they said there was no proper legal action at the appellate level because in order to have, and John Eastman, who's a legal expert, said this on Hugh Hewitt's program last week, in order to have a legally binding decision that affects the whole state of California, you have to have an appellate court rule on this, but it can never get to the appellate court because there's nobody who can defend it. And Eastman said, look, if you have a collusive ruling where both parties in the courtroom want the same outcome, there's no adversarial component to the proceedings, you can't have any kind of a precedential ruling from an appellate court. Well, by definition, it would be impossible now for Prop 8 ever to get into the appeals court at the Ninth Circuit. So I don't understand when the Ninth Circuit Court almost instantly, I mean within an hour, within a half an hour, after receiving word from the Supreme Court on this ruling, they had removed their stay and legitimized same-sex marriages in California. My understanding is that they have no authority to do that. Am I right or wrong about that? I mean, this is if we were following the law.
Yeah, you're absolutely right, and it's been one of many. Let's call them judicial irregularities in this case, and it's disturbing because the Supreme Court has a 25-day window that once they make a decision, that decision doesn't go into effect. It didn't go down to the Ninth Circuit again for 25 days, and the purpose of that is to work out the details of the decision. If there are other appeals or motions for reconsideration, that gives time for that process, and that was completely disregarded in this case. The Ninth Circuit just went into effect immediately, and like I said, that's been the pattern. And Professor Eastman's right that this is this case will never have a appellate decision. One lone district court judge in San Francisco struck down the statewide initiative that millions and millions of Californians voters voted in favor of marriage to define marriage as a union of a man and a woman, and that's nullified by one judge.
Now, I'm looking at this piece on Breitbart.com. Liberty Counsel's got the same information, that the Ninth Circuit received a letter from the Supreme Court at 2:54 p.m. On June 26, just hours after the decision was published. And this is what the letter said. The judgment or mandate of this court will not issue for at least 25 days, pursuant to Supreme Court Rule 45. So in other words, what they said is this is not going to be an official mandate for 25 days, so you got to hold off on all these marriage licenses and all that stuff. This isn't official until 25 days after June 26. But then, after being explicitly informed by the Supreme Court, at 3:23, the Ninth Circuit dissolved its stay. So they get the letter 2:54. 29 minutes later, they defy the Supreme Court. They ignore part of the ruling the Supreme Court issued. They liked part of it, so that they implemented in 29 minutes and ignored the rest. So they're in defiance of the state Supreme Court. And despite being legally bound to adhere to the formal rule of law, California Attorney General Kamala Harris tweeted at 3:35, 12 minutes later, that she was on her way to San Francisco City Hall to marry plaintiffs in the Prop 8 case. So obviously a huge rush to judgment. People had to be tipped off and all that kind of thing. But here's my question, talking here with Dale Schowengerdt, Alliance Defending Freedom. Here's my question. If they had allowed this 25 days to elapse, would the Ninth District at that point have the legal authority to impose same-sex marriage on the state of California? Because I thought the Supreme Court said nobody's got standing here to defend this other than the governor and the attorney general. If they don't, it never gets to the appeals court. And unless an appeals court issues a ruling, then the statute stays in place. It can only be overturned if you have a ruling issued by an appeals court. So is your understanding if they'd waited 25 days, they could do what they did? Or if we were following the law and the Constitution of California, would they still not be able, technically, legally, constitutionally, to do what they did? Help me on that.
Well, they would. It gets a little bit technical, but after the 25 days, they would have been able to do one thing. They would have been able to send the case back to the district court. That's the only thing the Supreme Court allowed them to do.
All right.
And then that would have dissolved the stay, and so the case as it applied to those plaintiffs and maybe the two counties that were involved in the case, that's what it would have affected. So it would have affected those parties in the case, not a statewide. There's just no authority for a statewide nullification of Prop 8, if that makes sense.
Yeah, it does, and that's what I'm getting at. So if I understand you correctly, Dale, then if we were a nation that observed the rule of law and the Constitution, we weren't this chaotic rule of man kind of society, which is what we have devolved to. But if we were still operating under the rule of law and the authority of the Constitution, then Proposition 8 would still be the law of the land in the entire state of California, except for those two couples that were in Von Walker's courtroom.
Right, and maybe those two counties that were involved in the case. That's right. That's and so that should really concern both sides of this debate, and I think it does privately concern even proponents of same-sex marriage, because they realize that this is a sham. I mean, this is disregarding the rule of law, and that should be concerning to everyone who cares about the rule of law.
Now, let me play a soundbite for you, Dale, and then I want you to respond to this. This is Bob Schieffer talking with Tony Perkins of the Family Research Council yesterday on his program. I forget what Bob Schieffer's, Face the Nation, I think, it's on CBS. Anyway, you know, you and I know, Dale, that we've had Christian businessmen. We've had this baker in Colorado refuse to bake a cake for a same-sex ceremony. I mean, same-sex couples can't get married in Colorado. So they got married in Massachusetts, came back to Colorado, wanted to have a little celebration, asked this guy to bake a cake for him. He says, no, I'm sorry, I can't. My Christian conscience won't allow me to do that. Plenty of other people to bake it for you, but I'm not going to be able to do it. We know this florist in Washington, same deal. She was asked to do a floral arrangement for a same-sex wedding. She said, no, I'm not going to be able to do it. We've had the photographer in New Mexico fined $6,700 because she politely declined to film a same-sex, a lesbian commitment ceremony. So you and I know about this, and here is Bob Schieffer talking to Tony Perkins, and he has absolutely no idea that these cases, these lawsuits have been filed. Let's listen.
How is it that bakers and florists are being forced to participate in this? I'm not sure I understand what you're saying here.
Well, we're seeing in Washington State, Colorado, and some of the other states that have these anti-discrimination statutes that are being imposed, that when a same-sex couple comes and says, I want you to take pictures of my wedding, or I want you to bake a cake, and they say, well, look, my religious convictions will not allow me to participate in that. They're literally being sued by the government, not the individuals. And they've even been adjudicated in such places as New Mexico. So we're going to see a loss of religious freedom. There is no question about it. It's already happening.
How many lawsuits have been filed on that? Because I must say this is under my radar. I haven't heard this.
Well, you know, Bob, that's a great point, because the media is not reporting on this, because they realize there's a lot more behind this than the marriage altar. It's literally about altering the landscape of America.
So what do you make of that, Dale? We got about 45 seconds. What do you make of the fact that Bob Schieffer, one of the leading newsmen in the United States of America, has absolutely no idea that religious liberty is under assault because of same-sex marriage?
Well, you know, Alliance Defending Freedom is counsel in many of those cases. In fact, I'm lead counsel on the Washington Florist case. So I wish I had a lot more than 45 minutes or seconds to talk about it, because it's extremely disturbing, because this is an enormous threat to religious liberty. We had a hearing in the Washington Florist case last Friday.
Hey,
a
Dale,
very mundane. Yeah.
Dale, would it be possible for you to hang on for just about 3 minutes after the break? Can you do that?
You bet.
Okay, well, if you'd be willing to hang over, I'd like to talk with you about that Washington case, because that illustrates everything that that kind of manifests or displays the concerns we have over the threat to religious liberty. So if you can hang on, I'd love to have you kind of walk us through that and give us an update about where things stand. Our guest, Dale Schowengerdt, who is attorney with the Alliance Defending Freedom, lead counsel on one of the cases that represent one of the remarkable, ominous threats to religious liberty in America. That's a florist in the state of Washington, being sued now, not by the customer, not by the homosexual customer who was unhappy that she wouldn't do it. In fact, he wasn't even unhappy. Maybe Dale can elaborate on this, but my understanding is after she turned him down, he was a long-term customer, 9 years, and when she politely turned him down, they had a hug and an embrace. He wasn't upset at all. The Attorney General is the one taking her to court. Focal Point AFR Talk.